Welcome to Thursday live stream. We're just starting now. Hope that all these devices working. Let me see TikTok. I think they were live right now, ready to go. Yes, and also YouTube and Instagram. For those of you who joined from TikTok, YouTube, and Instagram, we'll be able to post the questions and comments, and then I'll be able to answer some of them. And then for those of you watching and joining from Facebook, LinkedIn, you'll be able to just see them live or later. So thank you so much for all of you joining today. Today is June 12th. I do this every Thursday, 5 p.m. Central Time. But next week, I will be out of town. Hey Pedro, how are you? Thank you so much for joining from YouTube, our client. But the next Thursday, I will be out of office in town, so I will not be able to have this live. So sorry that there is no live next week. I'll be out of office for next week. So I'm gonna repeat this multiple times that there is no live next Thursday. I'm just waiting for people to join, and then now, so we're gonna start. Okay, so I'm attorney Jae Francis. I'm a U.S. immigration lawyer based in Chicago and Wisconsin, but serve all 50 states. I do this live stream every Thursday, 5 p.m. Central Time, but except next week, I'll be out of office, so out of live stream as well. So there's no live. Okay, so we have some question here. Jackie's, right? So if you submit your application of status now, okay. So I'm just guessing that your case is marriage-based AOS, and then if you submit your case now, what happens? I mean, multiple elements and answer to your questions, but except some parent cases, right? The child over 21, U.S. citizen file petition for parents, then usually they don't schedule interview even under Trump, but all other cases will be scheduled for interview. So I think that that's probably answer that you're looking for. But if you have any follow-up questions, let me know. But you're the first one. Okay. So, oh yes, yes. Lutlot, hopefully I'm just pronouncing your first name correctly, Chavez, right? Thank you so much for chiming in. Yes, I do this every Thursday, 5 p.m. And then while I'm waiting for some of you to join, I'll start with this topic, okay? So for those of you who enter the U.S. without inspection, it means that no visa, no ESTA, you cross the border under Biden, and then you have a pending immigration case, right, with the immigration court, right? It's called removal proceeding. You have an NTA, notice to appear. Now, what you have is that maybe by now you file your 589 asylum application, and then you have work permit and all this. You probably work with a notario, right? Not the regular attorney, but non-attorney notario. And then you have an upcoming master calendar hearing, which is a scheduling hearing. And then you heard about this news that what happened is that ICE snatched many, it's called respondent, those who attend this removal proceeding called respondent from the immigration court. What happened is that if you enter less than 2 years ago, right, and then you attend the hearing, immigration hearing in person, what they do, even in Chicago sometime, is that the ICE attorney, the government attorney, dismiss your case, say that you don't have a case with the immigration court, that ICE wait outside because you're subject to expedited removal. So if you enter without inspection and then you enter less than 2 years, even if you have a pending asylum case, but if you enter or go to your court hearing in person, then you could be subject to expedited removal. It means that you don't you don't have any hearing, you don't have any case before immigration court. They can ship you out right away. So what's the solution? Then if you have an attorney, right, immigration attorney, and then file this, it's called WebEx, right? So then you know the WebEx and Zoom, all this video conference tool. Then if your attorney file WebEx motion, or sometime your assigned immigration judge will do WebEx without motion, then you don't need to go to court in person. Sadly, that's the only way, the best way to avoid expedited removal. So that's like intro for today. Lexi, I'll get back to Pedro and then go back to the TikTok. So from Lexi, YouTube asked the question. So what about you overstay your visa, and married to a permanent resident, right? You said married to a green card. You're saying that married to a permanent resident, right? So you may clarify what's the best option. Call us, right? You see the phone number. The reason why I'm saying is that, unless your I-130 petitioner becomes a U.S. citizen, your unlawful presence and potential unlawful employment will not be forgiven. So you need to be very careful with this. And in fact, if you get married to a permanent resident, at this time, you're not able to submit I-130 and 45 at the same time. But at the same time, this is very convoluted. I'm sorry, just like but, right? But it's a good idea to submit your I-130 at this point, because without any benefit application pending with the USCIS, you may be subject to removal proceeding, or sometime if you're unlucky, then expedited removal. So you need to be careful. So you call us. So for those of you who's contacting and then joining from YouTube, you see the phone number. For those of you who's joining from TikTok and Instagram, I'm not able to tell you your phone number, my phone number. So you need to, go to my profile section, Dr. Jae Francis Immigration, and you'll find the phone number. Pedro, I'll get back to you. Okay. So let me check the TikTok, see whether there's any questions here. Some of you join. Okay. So thank you so much for joining this. Okay. You see that sometimes I scroll with the finger because I use iPad for TikTok. Okay, good. So Labi Singh, after green card interview, okay, so Labi's situation is this. So then looks like marriage green card case, attended interview, and then there's a home visit by USCIS, not by the ICE, USCIS, right? And then when officer came to visit them, both of them were home. So then what they do is that when USCIS visit you, they don't come 1 a.m., 2 a.m. That's ICE. USCIS come usually 6 a.m., 7 a.m. Knock on the door. The USCIS, they don't send agents to arrest you or detain you. That's usually ICE. So if it's a USCIS, you can ask, are you USCIS, or who are you? And then they identify that they're USCIS. Then you have a pending marriage green card case. Good idea to open the door. So you open the door. What happened is that they like to check your ID, right? Especially foreign spouse, passport. And then what they like to do is that they like to make sure that you live together. How would they know? They can easily see. But what they look is a closet. They go to master, bedroom, and then they can easily see whether your couple live together or sleep together or different room, and then open the closet, right? Usually, newlywed couple have clothing together, so you don't separate. Hey, it's my closet and you have yours. If you're newlywed, I can be wrong, but that's what they look. So they look at your closet. Okay. So Amanda asked the question, I got my divorce decree yesterday. Can I marry next week and file for AOS? Now, if you're from Wisconsin, and then if your divorce finalized in Wisconsin, answer is no, because there's a 6-month cooling period. It means that once your divorce finalized in Wisconsin, you cannot marry someone right away. You need to wait 6 months. But if there's no cooling period, wait period, then you may go ahead and then get married and apply for green card. Okay. So you have a bank statement, pictures, and insurance. That's good. Marriage certificate only. You're you need a long way to go. Amanda, I think that this is really important case for you. If you do it correctly, then it'll be a good investment. What I'm trying to tell is that probably you need to work with attorney because we tell our clients how to develop their cases, right? Make your case stronger. Why do I tell you that you need to work with attorney more than ever? Because according to USCIS regulation and then policy and enforcement, when they deny your case, AUS package, 751, N400, all this, when they deny it, they will place you into removal proceeding. That's what they're going to do. That's what they're telling us. So then instead of just denying your case, not that, Amanda, your case will be denied, but if your case is denied, then, in the past, before Trump, you refile all this, but government will place you into removal proceeding. So what's the difference? Because once you're placed into removal proceeding, then under Trump, it'll be very difficult to dismiss your case with the immigration court. What you need to do is that with the help of immigration attorney, you need to adjust your status, marriage base, before immigration court. It'll be marriage trial before immigration judge. We're highly successful, but it may happen to you. So just be careful filing cases now, adjustment of the status, 751 and 400, because if they deny your case, they will place you into removal proceeding. They're serious about this. So just, be careful. Okay, I'm just looking at TikTok. Lobby. Okay, so then Lobby is the one that mentioned that after interview, USCIS agent visited your home. You're saying that maybe it's been 84 days since your interview. Usually, you need to wait 120 days to start contacting USCIS. So you need to wait a little bit to start contacting. Okay, but I hope that they approve your case. Okay, the law, right? That's the ID. My I-130 is delayed. Why? I mean, how long have you waited? I-130 has a many different variation. It can be consular process I-130. It can be I-130 as a first step toward 601 waiver, or I-130, the first step in the conjunction of removal proceeding. Usually, consular process I-130 is relatively fast, minimum 1 year, a little bit longer. But if you happen to have I-130 in the context of 601A waiver or removal proceeding, it takes more, so maybe 18 months. Okay, so Amanda, you have a lot of good questions, but still, I believe that you should hire an attorney. If you need an attorney, just contact us. Okay, you have a phone number. But thank you for asking good questions. Okay. Okay. So Trinidad asked question. Very good question. So why would K1 cases denied? We don't have any denial. So, but sometimes we talk to potential clients when their case is denied. So I'll give you some common scenario, right? So, for example, the K1 fiance, right, has complicated previous marriage or have a multiple previous K1, okay? But the most common scenario would be if your fiance is from culturally, religiously conservative society like India or Middle East, then this is what's going to happen. So in culturally, religiously conservative society, K1 fiance, right, U.S. petitioner, you're not supposed to stay in hotel, like have a vacation, just like American couple or boyfriend, girlfriend, because that's not expected. That's not allowed in culturally, religiously conservative society. And then if you do this, like you're spending hotels, and then you do vacations and all this, that you went to Europe together, then they think that you're married couple, because like I said, culturally, religiously conservative society, then you're not supposed to do any of this. Very controlled dating, right? So during the day, but not at night. Okay. So that's the most common reason for K1 denial. Okay. Okay. Well, yeah. Punisher asks, how much is for consultation? So for attorney consultation, it changes a little bit, but usually we offer consultation up to 45 minutes, and then that's $200 consultation with attorney. It can be with me if you choose us, or it can be with Alicia, and then that's our fee. So 45 minutes, and then about it's not about, it's a $200. Okay, Brock. Okay. Oh, you have a very good question. So, your wife, right? Brock's wife has an individual hearing, the final one in July, and then you file I-130 and 45. Okay, looks like you filed I-130 and 45 quite some time ago, because you waited this much, right? So it depends on how you work with attorney. It's gonna determine, but. No, I'm just surprised that I-130 is not approved. I-130 is not approved. Okay, and then your 45 is still pending. So this is what happened. Okay, right now, you submit I-130 and 45 with this pending removal proceeding. Is that what happened? Is the USCIS will schedule interview for I-130 and 45 about 2 or 3 months after you submitted everything, and then they will approve your I-130 only, but place your 45 into admin closure because you have a pending removal proceeding. Then with this, you ask the court to schedule merits hearing, individual final hearing, and then you adjust your status before the court. And then when the court approve your case, then you go back to USCIS and get a green card. So that's usually set up. But Brock, looks like you and your wife submitted your case a long time ago. I-130 45 still pending. But basically, because your individual hearing is next month, you're gonna adjust your status before the court. Okay. So Badi asked the question. So I'm just drinking some water. Sorry. So then Badi has potential marriage green card case, right? Mentioned 130 45 interview schedule. What's my advice, what to expect? More than ever, more cases scheduled for separate interview. You don't know whether your interview will be together or separate, so you'll know at the beginning of interview. So expect that you could be interviewed separately, number one, right? Number one. And number two, the USCIS will review all previous immigration history. So for example, if you enter with a tourist visa, they're going to take a look at it. If you submit a 539 change of status from B2 to F1, they're going to take a look at it. Especially if you apply for asylum in the past, they're going to review it as well. So that's the second trend right now happening here. The third one, maybe we do our case exceptionally good, but in the past, our clients brought additional relationship documents, and then not the attorneys, but USCIS officers review them either in person later. But more than ever, they say, I don't need it. And then they approve the case anyway. So we're happy. But don't expect that, you have a really meaningful second chance to bring additional documents. Just don't assume that, because they probably review your case already and decided what to do with your case. But have a good interview, okay? Buddy, good luck with it. Now, Ella, your question is interesting. Are you seeing any 751 approvals? Of course. If you file 751 together, then it takes about 18 months, right? If you file waiver individual, then it'll take about 3 years, and then there will be interview. So if you file individual filing 751, then it takes 3 years minimum. Okay. see. Let me see. Yeah, so then 35 star asked the question, can immigrant marry a green card holder? Of course, you can marry anyone, US citizen, foreign national, and permanent resident. But your question is, then what's your green card pathway or your immigration option? As I mentioned, that if you get married to a permanent resident and if you're overseas, it's called to F2A consular process. It takes between 3 and 5 years. 3 and 5 years. Now, if you are inside the United States, then you're not able to submit 45 and I-130 at the same time. It'll be just I-130. So you need to be careful because any unlawful employment, unlawful presence will not be forgiven. So, Badi Ella, thank you so much for asking excellent questions. So, hope to talk to you soon. See you next time. Okay, Christabel. Are you like Christabel, our client, or just other Christabel? Hard to tell because I see your name only. But if you are client Christabel, then let us know. Okay, I'm just a little bit behind, so I'm just trying to catch many of them. Okay. Okay. Jason. Jason. Okay. I see. So then this is what you're asking, Jason. So you're illegally here, right? If person is illegally here, it means that either visa overstay or entry without inspection. Then the child, right, is over 21 and U.S. citizen. Looks like that's going on here. So there's a two different situation. Now, if you enter with a visa in overstay, then your over 21 U.S. citizen child will be able to file a petition for you, and then you will be able to adjust your status to permanent residency. Answer is yes. But if you enter without inspection, then even though your child may be able to file I-130 petition for you, you need to go through 601A waiver, 601A waiver, and then child is not qualifying relatives. It means that you need a U.S. citizen permanent resident spouse or U.S. citizen permanent resident parent. So, but when in doubt, you can call us, right? Go to my profile section, Dr. Jae Francis Immigration. There's a phone number. When you call us Monday through Friday, 8 to 4 Central Time, then you'll talk to Maria. She will give you a case evaluation. Or if you call us outside of this window, you'll talk to intake specialist. But if you want to talk to me directly, and there's a sign-up link. Right now, 30 minutes, 150, but soon it'll be 45 minutes and then $200. So, no, I'm sorry. Yeah, I'll stay the same. I'm sorry, just tired. 30 minutes, $150. Okay. Okay. Seed. Okay. Seed J, your sorry. So spousal visa case, I-130 still pending. When did you submit your case? Let me know. Brock. Okay. Okay. So Brock is the one that individual hearing is coming on July, and you just submitted I-130 and 45. I mean, I'm sure that you're working with attorney. Your attorney may have a good ideas, but usually what we do is that we don't schedule individual hearing right away when I-130 is pending. But I'm not like the master of all this, so I can be wrong. But you will be adjusting before immigration judge. Okay. So then Love provided more information. I-130 was approved in October 2024 and then went to NBC. So depends on your nationality. Love, I don't know whether your I-130 petitioner is U.S. citizen or permanent resident. Maybe I missed that, but yeah, you didn't tell me. So if your I-130 petitioner is a permanent resident, there will be quite some additional wait time. But even if U.S. citizen, sometimes there's quite a bit of wait. Consular process takes longer now. Oh yeah, Christabel, our client. Yes, of course, her case was approved, so she wanted to say thank you. We got email as well and then review. Thank you so much. but we're just happy for you, So marriage green card case, right? So just attended interview and then it was approved fast. We're happy. So some Massachusetts case. We're happy for you. But we'll talk to you later. What comes next. We're gonna talk about your next case and all that later. Oh, thank you so much, Christabel. Yeah, we work hard and then we enjoy working with you. Thank you so much. Okay, so I'm gonna look. Lot asked the question here. Your cousin overstay his visa. Okay, so visa overstayer, and eventually married to you, U.S. citizen. Okay, file I-130/45 2 months ago. 751. Oh, I see. What? 751. Okay. Just sorry. Okay, so then it's a 751. So then your cousin's case approved, right? So he got or she got CR6, right? 2-year conditional residency, and then just filed 751 and then got 48 months. And then overstay will affect 751 case. Not really. Visa overstay will not affect him. But by the way, I explained this, right? You probably know that the government may go after visa overstayers because of this incident happened in Colorado. Remember that person from Egypt entered with a tourist visa and then apply for asylum within 6 months, admission period expiration, and then he, hurt people. But the government is accusing him or labeling him as a visa overstayer. That's not true. And they say, aha, because of this, we're going to go after visa overstayers. So with no criminal records, no final removal orders, anything, if you overstay, then government say that we're going to go after you. Going back to Lotla's question, the 751 10-year green card removal condition, your cousin should be okay. So then he visa overstay, but became permanent resident. So he should be okay. Okay, so then Nana asked the question. Ooh, I touched the screen and then it just like bump. Sorry. Nana, where are you? Okay, sorry. Once I miss you. Okay, okay, I found you. Okay. So what happened to someone that came through the border, asylum denied? I think that when you say asylum, you're talking about credible fear interview, and then you're talking about what happened previously because they don't do this anymore. So there's someone trying to enter the country through the border, and they said I fear persecution, and then credible fear interview denied. Then what other options? Not really. There is no other easy option. I'm really sorry to tell you, but this person may get married to U.S. citizen and then start marriage-based option later. Okay. Okay. So then Hania asked very important question. So according to Hania, the question is this. So what happens to already approved K1 with travel ban? So then the question is that there is a 12 completely banned country that K1 is not allowed, right? Based upon our understanding. If you are from 7 partially banned country like Venezuela, K1 may be allowed. So then I don't know whether, Hania, you're referring to 12 completely banned or partially banned, but this ban, right, the travel ban started June 9th. So unless you're here before June 9th, then if this person belongs to 12 country, then my understanding is that person is not allowed to enter the US. So, but I can be wrong. So talk to your attorney, okay? So Mrs. Walker, right? Mrs. Walker, you got married to US citizen last year. You haven't applied for a green card yet, and then are you in jeopardy? I wouldn't say so, but depends on how you enter, right? If you enter the US, right, and overstay and got married to US citizen, hurry up and apply for marriage green card case right away, because unless you have a benefit application in system, they may go after you. Remember, I told you, government may go after people who just simply overstay the visa. They may place you into removal proceeding or even subject you to expedited removal. But having said this, okay, you may contact us, Mrs. Walker, if you need an attorney. You can find the phone number on our profile. So thank you so much for joining this live. As I explained earlier, that I will be out of office and out of town next week. So I will not be able to host the live. It's been a while. I had consecutively, right, hosting this live every Thursday, 5 p.m. So there is no June 19 live. I will miss you. But when I come back, I will resume this Thursday live for you. So thank you so much for joining from TikTok, YouTube, and Instagram, and Facebook, and LinkedIn. I'll see you, I believe, the 26th, June 26th. There is no live next week. Thank you so much. Peace be with you.